More than 150,000 cases are pending resolution in Ugandan courts, and many of them are in the civil division of the High Court. According to the Chief Justice, Alfonse Owiny-Dollo, these disputes amount to over 7 trillion shillings, which is about 7% of Uganda's annual national budget. Although there have been efforts by the judiciary to clear this backlog, it has not yielded much due to manpower challenges in the courts. Minister of Justice and Constitutional Affairs, Norbert Mao, now says, without giving much detail, that government is moving to clear this backlog through planned new legislation.
We are rumoring about enacting a speedy trial legislation, which is going to be debated, and of course we will consult the judiciary. Just like election cases are resolved within 6 months, there are some cases that need to be resolved as quickly as possible because they can slow down the economy, they can lead to people losing jobs, they can even bring down a bank, as you may have been seeing in newspapers.
Mao was speaking at the launch of a civil redress scheme by International Center for Arbitration and Mediation in Kampala, ICAMEC. It was launched by the Chief Justice, who called for legalization of traditional methods of conflict resolution.
And to me, this is the original mode of dispute resolution. And the sooner we address this, Mr. Minister, I've heard you say you want to come up with legislation. Maybe you need to look into this as well as a mode of quick, meaningful, and satisfactory dispute resolution.
Dollo referred to the actually traditional justice system where capital offences are atoned for by not only the wrongdoer but his or her extended family, and murder atoned for through compensation and concluded by a public notice known as mato oput, a method of reconciliation. Many countries have outlawed such traditional systems except in the Middle East and some African countries. But the Chief Justice thinks this should be the way to go, and the adversarial mode of conflict resolution should be an alternative.
In the African jurisprudence, it is not about winning, which is typical in the adversarial mode of dispute resolution. It is about bringing the parties together.
The International Center for Arbitration and Mediation in Kampala, which has an instrument to appoint mediators and arbiters, will under this new scheme push for reconciliation.
Is enjoined to bring the conciliatory aspect of alternative dispute resolution mechanism to the forefront, without complicating them with a more structured mechanism that come with mediation, for instance, and arbitration, and of course the court system.
However, under the current legal framework, reconciliation cannot be applied to all disputes. Edward Muhumza, NTV.